Welcome to FDVN Chanel with the program Learning Legal English Through Case Laws. Case Law No. 62/2023 AL1, on the starting time of performance of the support obligations for minor children in the dispute over the determination of a child's father, approved by Council of Justices the Supreme People's Court on February 1st, 2, and 3, 2023 and published according to Decision No. 39 QDCA dated February 24, 2023 of the Chief Justice of the Supreme People's Court. Source of the case law: Appellate Judgment No. 07/2018 HNPT dated March 22, 2018 of the People's Court of Binfawak Province on the marriage and family case determination of father for children, child support between the plaintiff Ms. LUheid T and defendant Mr. Trin C. The location of the content of the case law. Paragraphs 4 of the findings of the court section. Case law brief. Content of the case law. After the child was born, the mother initiated a lawsuit requesting to identify the defendant as the biological father of the child and requested the defendant to perform the support obligation for their mutual child. The court determined that the defendant was the biological father of the child and was obligated to support the child. Legal solutions. In this case, the court must determine the period of support for the minor child shall be counted since the child was born. Legal provisions related to case law. Clause 24, Article 3, Article 107, Article 110 of the Law on Marriage and Family 2014. Keywords of the case law: determination of the father for the child, support for minor children, the starting time to perform the support obligations. Content of the case law: plaintiff Ms. LUheid T presented. Ms. LUheid T and Trin C had been living together voluntarily since 2013 and held a customary wedding, but they did not register their marriage. As they could not live together, they requested the court to resolve the matter. The court decided that the marriage relationship between Ms. LUheid T and Mr. Trin C was not recognized in the Judgment No. 13/2017 HNGST dated March 31, 2017 issued by the People's Court of LUheid District, Binfawak Province. During their time together, Ms. D and Mr. C had a mutual child, LUheid P, born on January 12, 2014. LUheid P has been raised by Ms. D since birth. Ms. D filed a lawsuit requesting the court to determine that LUheid P is their mutual child with Mr. Trin C. She also requested the court to compel Mr. Trin to pay child support of 2 million VND per month from January 12, 2014, until LUheid P reaches adulthood. However, during the first instance trial, she changed part of her request that Mr. V be compelled to pay child support of 1,500,000 VND per month from January 12, 2014, until P reaches the age of 18. Defendant Mr. Trin C presented. Trin C admitted that the period of cohabitation and the court's decision not to recognize the parties as husband and wife as presented by Ms. LUheid T were correct. He also admitted that LUheid P is his biological child with Ms. LUheid T, who was born during their cohabitation as husband and wife. He acknowledged that there were serious family conflicts that led Ms. LUheid T to not allow him to be recognized as Mr. LUheid P's father and for the child to take her mother's last name. For the request to initiate a child support lawsuit at the request of Ms. LUheid T, he determined the above amount of child support was too high, exceeded his income. Mr. C only agreed to support 1,300,000 VND per month, starting from the date of November 1, 2017, until LUheid P becomes an adult. In the first instance marriage, Judgment No. 48/2017 HNST dated November 22, 2017 of the People's Court of LUheid District, declared, having recognized the agreement reached by Ms. LUheid T and Mr. Trin C. Having determined that LUheid P, born on January 12, 2014 is the biological child of Ms. LUheid T and Mr. Trin C, Ms. LUheid T has the right to take care of and nurture LUheid P until LUheid P becomes an adult. Regarding the level of support and time to perform the support obligation, Mr. Trin V was forced to provide child support for LUheid P every month in the amount of 1,500,000 VND until he reaches 18 years old. The support period was calculated from the date October 12, 2017 until LUheid P reaches 18 years old. In addition, the judgment also declared the court fees, judgment enforcement obligations and the right of appeal of the involved parties, On November 27, 2017, plaintiff, Ms. LUheid, filed an appeal with the content, having requested the People's Court of Bin Pharak Province to hear an appellate to amend a part of the first instance judgment number 48/2017 HNST dated November 22, 2017 of the People's Court of LUheid District, Bin Pharak Province, forcing Mr. Trin Vin C to pay child support for LUheid P. The period was calculated from the time he was born on January 12, 2014 to October 12, 2017, which is 45 months, with the amount of 45 months x1. 500,000 VND month equals 67,500,000 VND. On November 30, 2017, the defendant, Mr. Trin Vin C, filed an appeal disagreeing with the support rate of VND 1, 500,000 month as declared by the first instance judgment. He requested the People's Court of Bin Pharak Province to lower the level of support to 1 million VND month. In addition, Mr. C also asked to adopt P without any support from Ms. D. The representative of the procuracy participating in the appellate hearing proposed that the trial panel should base on Clause 1, Article 308 of the 2015 Civil Procedure Code, do not accept Mr. C's appeal, do not accept Ms. D's appeal, and uphold the decision of the first instance judgment number 48/2017 HNST dated November 22, 2017 issued by the People's Court of LUheid District, after researching the documents in the case file, verifying them at the court session, and based on the results of arguments presented at the trial, opinions of the procurator and the involved parties. Findings of the court. 1. Considering Mr. C's appeal request to raise LUheid P without Ms. D's support, it was found that Ms. D alone took care of, physically and mentally nurtured LUheid P since P was born. The fact that the first instance court decided to hand P over to Ms. D is appropriate, so Mr. C's appeal on this part is unfounded. 2. Considering Mr. C's appeal, he requested the People's Court of Bin Pharak Province to lower the level of support from 1,500,000 VND month to 1 million VND month. It was found that, according to the verification minutes of the People's Court of LUheid District, File 33, the average cost to taking care of and raising a child of the same age as P is 3 million VND month. Therefore, the Court of First Instance obligated Mr. C to support P with an amount of 1,500,000 VND per month, 3 million VND, 2 persons equals 1,500,000 VND person, which is appropriate. Mr. C is a teacher with a stable monthly income of 4,666,220 VND, File 18, thus Mr. C's appeal to reduce the level of support has no grounds for acceptance. 3. Considering the appeal of Ms. LUheid, who requested Mr. Trin Vin C to return the money that she alone spent to support LUheid P since P was born on January 12, 2014, until October 12, 2017, the date she filed the lawsuit, which is 45 months with an amount of 45 months x 1,500,000 VND month equals 7,500,000 VND. It was found that, at the appeal trial, Mr. C admitted that P is his child and that Ms. D has been raising P since his birth because Mr. C has not been recognized as the legal father of P. However, when Ms. D gave birth, Mr. C gave her 5 million dong to prepare. After that, Mr. C provided an average of 5 months per year of child support, giving 1 million VND per month. Ms. D only admitted that Mr. C gave her 5 million VND to prepare for the birth and gave her 1 million VND 3 times. 4. Considering the provisions of Articles 82 and 83, Clause 24, Article 3, Article 107, 110 Marriage and Family Law in 2014, Article 281 of the 2005 Civil Code, the obligation of parents to provide support for their minor children arises from the time of the child's birth. Child support is the right of the child and the obligation of the father and mother to directly raise the child. LUheid P is the mutual child of Ms. LUheid and Mr. Trin Vin C, but from the time of P's birth on January 12, 2014, until October 12, 2017, the day Ms. D filed a lawsuit to request support. Ms. D alone took care of, nurtured and paid for the child's expenses. Thus, the first instance court's decision to not force Mr. C to reimburse Ms. D for the costs she incurred in raising P from birth until the day she filed the lawsuit on October 12, 2017, was inappropriate and would affect Ms. D's legitimate rights and interests. Therefore, part of Ms. D's appeal is accepted, and Mr. C is ordered to pay back to Ms. D half of the amount of 2 million VND month that she spent raising P from January 12, 2014, until October 12, 2017, which comes to 45 months x 1 million VND month equals 45 million VND. 5. Mr. C claimed that he had provided support to Ms. D for an average of 5 months per year, with 1 million VND per month to raise her children. However, he was unable to provide any documents or evidence to support his claim. Ms. D admitted to receiving support from Mr. C only 3 times, with 1 million dong each time. Therefore, the court could only accept Mr. C's child support for those 3 months. Ms. D received a total of 3 million VND in child support during this time. This amount should be deducted from the total amount of child support that Mr. C owes Ms. D, which is 45 million VND. Therefore, the amount that Mr. C must pay Ms. D is 42 million VND, 45 million VND, 3 million VND. 6. Regarding the amount of 5 million VND that Mr. C gave to Ms. D, it was meant to cover the cost of childbirth and cannot be deducted from the amount of child support owed. 7. The point of view of the representative of the People's Procuracy of Bin Pha Wat Province in not accepting Mr. C's appeal to reduce the support level is grounded. 8. The opinion of the representative of the People's Procuracy of Bin Pha Wat Province, asking not to accept Ms. D's appeal requesting Mr. C to pay child support from January 12, 2014 to October 12, 2017 is unfounded. 9. Other decisions of the first instance judgment without appeal or protest took effect from the date of expiration of the time limit for appeal or protest. 10. Court fees for appellate marriage. Mr. Trinh Vinh C must bear the legal costs in accordance with the law. For the above reasons, decide TO, pursuant to Clause 2, Articles 308 and 309 of the 2015 Civil Procedure Code, Resolution No. 326/2016 UBTVQH14 of the National Assembly Standing Committee on Court Fees and Charges, the appeal request of Mr. Trinh Vinh C was not accepted, partially accepted the appeal request of Ms. LUheid D. Amend the First Instance Marriage and Family Judgment No. 48/2017 HNGST dated November 22, 2017 issued by the People's Court of LOC Ninh District. According to Articles 3, 14, 68, 69, 71, 82, 83, 107, 110, 116, 117, 119 of the Law on Marriage and Family 2014, Article 281 of the Civil Code 2005. 1. Recognize the agreement reached by Ms. LUheid D and Mr. Trinh Vinh C. It was determined that Legia P, born on January 12, 2014, is the biological child of Ms. LUheid D and Mr. Trinh Vinh C. Legia P has been assigned to Ms. LUheid D to be cared for and nurtured until Legia P is 18 years old and able to work. 2. Mr. Trinh Vinh was forced to return the joint child support payment of Legia P to Ms. LUheid D from January 12, 2014 to October 12, 2017, which is 42 million VND, 42 million VND. 3. Mr. Trinh Vinh C was forced to support the mutual child Legia P. Mr. Trinh Vinh C was forced to provide financial support to Ms. LUheid D for the care of their mutual child, Legia P, in the amount of 1,500,000 VND, 1,500,000 VND, per month until Legia P reaches 18 years old and is able to work. The support period began on October 12, 2017, which is the date when Ms. D filed the lawsuit. 4. The first instance marriage court costs of 300,000 VND must be borne by Mr. Trinh Vinh C. Ms. LUheid D was not required to pay it. As a result, the Civil Judgment Execution Department of LOC Ninh District, Bin Pha Wat Province refunded Ms. D the 300,000 VND court fee advance paid according to the collection receipt number 00148898, dated October 12, 2017. 5. The appellate court cost of 300,000 VND for the marriage case must be borne by Mr. Trinh Vinh C. The cost was deducted from the amount of court cost advance that he paid according to receipt number 0005554, dated November 30, 2014, issued by the Civil Judgment Execution Department of LOC Ninh District, Bin Pha Wok Province. 6. From the effective date of the judgment, there is a petition for judgment enforcement by the judgment creditor until all the money is fully paid. The judgment debtor must also pay interest on the remaining amount of the judgment debt at the interest rate specified in Clause 2, Article 468 of the Civil Code 2015, if the judgment is executed according to the provisions of Article 2 of the Law on Civil Judgment Execution. Both the civil judgment creditor and the civil judgment debtor have the right to reach an agreement regarding judgment enforcement, the right to request judgment enforcement, the voluntary execution of judgments, or to be forced to execute judgments as prescribed in Articles 6, 7 and 9 of the Law on Civil Judgment Execution. The statute of limitations for judgment enforcement shall comply with the provisions of Article 30 of the Law on Civil Judgment Execution. 7. Other decisions of the first instance judgment without appeal or protest took effect from the date of expiration of the time limit for appeal or protest. Content of the case law. Considering the provisions of Articles 82 and 83, Clause 24, Article 3, Article 107, 110 Marriage and Family Law in 2014, Article 281 of the 2005 Civil Code, the obligation of parents to provide support for their minor children arises from the time of the child's birth. Child support is the right of the child and the obligation of the father and mother to directly raise the child. Legia P is the mutual child of Ms. Lathai D and Mr. Trin Vin C, but from the time of P.S. birth on January 12, 2014, until October 12, 2017, the day Ms. D filed a lawsuit to request support, Ms. D alone took care of, nurtured and paid for the child's expenses. Thus, the first instance court's decision to not force Mr. C to reimburse Ms. D for the costs she incurred in raising P from birth until the day she filed the lawsuit on October 12, 2017, was inappropriate and would affect Ms. D's legitimate rights and interests. Therefore, part of Ms. D's appeal is accepted, and Mr. C is ordered to pay back to Ms. D half of the amount of 2 million VND month that she spent raising P from January 12, 2014, until October 12, 2017, which comes to 45 months x 1 million VND month equals 45 million VND.